This is Shane Clacken coming to you from Helena at our 69th legislative session here in Helena. And I want to clarify some stuff on House Joint Resolution 5 that I introduced last Friday. And what that was about was a convention for proposing amendments to the U.S. Constitution. There are 9 reasons why a convention of states is a controlled convention. This convention is to propose amendments. We have safeguards. Safeguard number 1, an amendments convention has no power to ratify. It can only propose amendments to this Constitution. A proposal to amend the Constitution is hardly a runaway. Congress has no limit on the amendment topics they can propose. Is that a runaway? No, because they need 38 states to ratify any proposal. Any proposed amendment by Congress or a convention is restrained by this practical consideration. Safeguard 2, a convention can only be called by Congress after 2/3 of the state legislatures have made application. The application sets the agendas. This is not foreign to our understanding. One who has applied for and received an antelope permit, for example, cannot legally shoot a moose. This is no different. Safeguard 3, when applying for a convention, state legislatures must state the purpose for which they seek it, and all state applications must aggregate on the same subject before Congress will call a convention. If this is not true, the 400 plus existing applications would be more than enough to call any subject convention, which has never been done. Safeguard 4, an amendment proposed by Article 5 convention cannot be ratified until forwarded by Congress to the states. The Convention of States cannot ratify its own proposed amendment. Safeguard 5, the federal judiciary may forestall the ratification of a proposed amendment that falls outside the scope of the convention's call. As an example, if you kill a moose with an antelope permit, you're outside the law and you must forfeit the moose when you're caught. Safeguard 6, 34 states at the convention fought vociferously to pass applications based on the same subject. Why would they then turn and reject all they have argued for to expand the convention to other subjects? In addition, states can recall any commissioner that seeks to go beyond their authority. And there's a case, Chafalo versus Washington in 2020, that states this clearly. Safeguard 7, all historical conventions operated as gatherings of independent sovereign states with one state, one vote rule. Current rules and all historical convention of state rules abide by this rule. A convention of states in 2017 wrote modern rules for a convention of states, including the one state, one vote rule. This convention was called for the purpose of drafting rules for balanced budget amendment convention, drafted the rules and adjourned. It did not run away. Safeguard 8, to move a proposal outside the call and the application, one commissioner would have to persuade their delegation and this delegation of other states to go along with this outside their power proposal in the face of recall by their state. This delegation would have to persuade the other state delegations the same, defying their oaths, their states, and subjecting themselves to public disgrace. Hardly likely. Safeguard 9, a proposed amendment cannot become part of the Constitution until 3/4 of the states have voted to ratify it. Only 13 states need to reject the amendment. That is a hard bar that cannot be changed and is set by the Constitution. This safeguard alone is enough to reject concerns of a runaway. This is specifically what Article 5 says. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution or on the application of the legislatures of 2/3 of the several states. They should call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by legislatures of 3/4 of the states, or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by Congress. The convention for proposing amendments is a convention of states. The Smith versus Union Bank case of 1831 bears this out. Other court cases and the historical uses of the term confirm this. This means the state's multiple court cases uphold the ideas that Congress has no role controlling the convention of states. You can look at the Idaho v. Freeman 1982 case or the Dreyer versus Blair case in 1975. The Shifalo versus Washington case in 2020 bears this out too. This case addresses states' faithless delegates to the Electoral College, although not fulfilling on point to a convention of the states. The principle that the state can control its delegates is upheld in this case. The Article 5 Convention's proposed amendments is not a constitutional convention that can open up the Constitution or rewrite the Constitution. An amendments convention can only propose amendments to this Constitution. Let's compare this restriction in Article 5 to our Article 14 of the Montana Constitution, which does allow for unlimited convention. I hope you learned from this, and the idea of a constitutional convention is not there. This is not a constitutional convention. It's a convention for proposing amendments to the Constitution, and it cannot run away due to these 9 safeguards. Thank you.